and then I'll give you a copy.
All right, so we're on the record in docket 25-00666 and 25-01005. That's set for preliminary examination day, and then we have a contempt hearing on 25-00666. I don't know why that keeps doing that. Will the parties please introduce themselves for the record? Mrs. Zell.
Thank you, Your Honor. Gabrielle Zell, Assistant Prosecutor for the people.
Mr. Palmer.
Thank you, and good morning, Your Honor. Robert Palmer of the Public Defender's Office, excuse me, on behalf of Mr. Micah Shabazz in both files. Mr. Shabazz is seated to my right.
And sir, you are Micah Shabazz, is that correct?
Yes, sir.
Thank you. This is the time set for a preliminary examination today and a contempt hearing. Mrs. Zell, how we proceed?
Your Honor, I believe that case with the contempt hearing today is the possession case. Is that correct?
Yes, that is there's a bond violation on that.
Judge,
I don't know if it's on the schedule. So
if I may, my understanding is this: there's 25-00666 is the possession of methamphetamine case.
Correct.
The other file, 25-01005 FY, is an assaultive case. The assaultive case, the people are unable to proceed on today, so I believe that one is going to be dismissed. 25-666 FY, Mr. Shabazz will be entering a plea on. However, as I understand it, at least the contempt on 666 FY is purely the fact that he was charged with the new case. Because that case is going away, I would also presume then that the contempt hearing would go away.
All right, and Mrs. Zell.
Your Honor, that's my understanding as well. Since that contempt is the underlying assault, or the underlying factual basis for that is the assaultive case that the necessary witness did fail to appear for after being subpoenaed. I would also be under the understanding that if the assaultive case is dismissed today, the contempt would be as well.
All right, and so let's proceed on. We'll proceed on both files, but let's do the so what are we doing on the 25-00666, the possession of methamphetamine?
That's going to be a plea to a misdemeanor use,
Okay.
Your Honor, the 1 year misdemeanor use. There's no sentencing agreement. I do have an advice of rights form completed by my client, if I may approach.
You may. So let's do that one, and we'll dismiss the contempt hearing, and then we'll go ahead and we'll address 25-01005, which is the assaultive crime that's responsible for the contempt hearing. Okay. All right. So I'm in possession of the advice of rights concerning this matter. Concerning file 25-00666, and Mrs. Zell, you can place the offer on the record concerning the plea offer, the misdemeanor plea offer.
Thank you, Your Honor. At this time, the people are offering a plea to an added count 2 of use of a controlled substance under MCL 333740423, which is a 1 year misdemeanor and or $1,000 fine. Upon successful plea and sentencing, we would be dismissing count 1, possession.
That would be a plea to the use of methamphetamine. Is that correct?
Correct, Your Honor.
And are there any other plea agreements concerning that matter?
There are not, Your Honor.
Is that a fair statement, Mr. Palmer? It is a plea to count the added count 2 of use of cocaine, which is a 1 year misdemeanor and $1,000, which you provided the advice of rights on, and then count 1 is to be dismissed upon successful plea and sentence.
That's an accurate statement, Your Honor.
All right. So, Mr. Palmer, may I inquire of Mr. Shabazz of his misdemeanor advice of rights?
Of course, Judge.
All right. Thank you. Mr. Shabazz, you understand, you've signed the advice of rights in this matter. These are 12 rights that you went over with your attorney, Mr. Palmer, and you signed the bottom of that. Is that correct?
Yes, sir.
Okay. So I'm going to go through the main rights with you concerning this matter. You have three main rights, and that's the right to be tried by a jury, to be presumed innocent, and to testify at trial. If you choose to testify, you may remain silent and it cannot be used against you. Do you understand that, sir?
Yes, sir.
If your plea is accepted, then you'll be pleading guilty to the misdemeanor of 1 year and/or $1,000 of use of methamphetamine and a dismissal of the felony count. That's the agreement. If your plea is accepted, you'll give the claim the plea was a result of any promises other than what we've stated on the record, or threats that it was not your choice to plead guilty. Do you understand that, sir?
Yes, sir.
You'd be giving up the right to appeal anything from trial since you won't be having a trial. You'll be pleading guilty to the use of methamphetamine, which is the 1 year misdemeanor. Do you understand that, sir?
Yes, sir.
I'm gonna have you raise your right hand. Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth under penalty of perjury?
Yes, sir.
Okay, thank you. All right, so I'm gonna bring your attention back, sir, to March 1st of 2025 at the offense location of 2025, 1,000 blocks it's the 1,000 block of Home Street in the city of Lansing. Were you present on March 1st, 2025 on Home Street in the city of Lansing, Ingham County? Okay, and at that time, did you use the controlled substance of methamphetamine?
Yes, I did.
And you knew it was methamphetamine when you were using it? Is that a yes, sir?
Yes, sir.
Okay. And you didn't accidentally use it, you used it to use methamphetamine?
Yes, sir.
All right. Anything towards a factual basis, Mrs. L?
No, Your Honor.
Mr. Palmer?
No, Your Honor, thank you.
All right. I find the factual basis to be knowing, voluntarily, and accurately made in regards to the factual basis for use of methamphetamine. Then we'll cover some of the other things. I would think, I don't know if he's in on this, Mr. Palmer, but we're going to refer to probation.
Yeah,
Yes,
and
yes,
yeah, he is in on this, Judge. He's in on this and the other case that I anticipate is about to be dismissed.
Right.
I was gonna argue a bond. Once we get there, I'm gonna request our
Right.
bond.
All right. So I don't know if you'll be out or in, but probation's on the 5th floor. And so if you're out, you have 48 hours to get to probation so they can meet with you. You can set them an appointment and they can do a report for me. All right.
Yes, sir.
And that's the 5th floor of this building. It's all the way to your right. All right. And we'll set a sentencing date for
June 27th at 9.
June 27th at 9 o'clock. All right, and then Mr. If I expect what's going to happen on the assaultive crime, Mr. Palmer, did you want to be heard on bond on this case?
Yes, Your Honor, and obviously this is with the presumption, I guess, that the other file, the assaultive case, is about to be dismissed.
Right.
I would ask that the court consider a personal recognizance bond for Mr. Shabazz. Mr. Shabazz did have a couple of things that were holding him in custody. That being these two cases primarily that are before the court today. Obviously, as the court's aware, we've gone from 2 felony files pending down to now what I anticipate will be 1 misdemeanor that he's entered a plea to, and a presumption at least of probation. The only other thing that's pending at this point for Mr. Shabazz, as I understand it, that's holding him in custody is there is a retail fraud 3rd-degree misdemeanor that I think the bond on that is $100. It's not before the court today, so I'm not asking the court to address it, but he hasn't posted it because of these other matters. Mr. Shabazz certainly seems to have getting things turned around. I recognize that there's been some delay in that, but Mr. Shabazz and I have had a number of conversations about this. I do think he's got things turned around. He's got a stable address to live at. I anticipate he's going to be working on employment and those kinds of things before he returns to the court in late June. I do think Mr. Shabazz will be a good candidate for probation. He really does have a lack of criminal history or lack of significant criminal history. I would ask that the court consider a personal recognizance bond, given that Mr. Shabazz's matters are now essentially largely cleaned up.
All right, and so I understand the nature. This was initially set a bond at 2,010%, and then it appears it was raised to 3,510%. probably pending, probably on the additional charge.
That's my understanding as well, Judge. And also then because of the bond violation, et cetera, it was raised. He's also got and that other assaultive crime had, I think, a $7,500 cash or surety bond. So those two matters were holding him. I think that now he would be eligible to be out released. He does have a couple of more court dates with the court. He's represented on a misdemeanor by James Harries of my office. Mr. Shabazz is aware of his obligations with regards to that. I don't anticipate having any problems with Mr. Shabazz returning to court or getting in touch with him. We have good contact information for him. I certainly think Mr. Shabazz understands his obligations and will return as necessary.
All right, thank you. Mrs. L, response to the reduction of bond motion, and I think you understand how the bond was previously set.
Correct, Your Honor. I do understand how the bond was previously set, and I would ask that if the court is inclined to change bond today, that it be reinstated to the original bond in this case. However, we would leave it to the discretion of the court. Thank you.
All right, thank you. I do have a failed to appear as of March 13th. I don't know if that had anything to do with the assaultive crime. It was originally set at 2,010% by Judge Simmons, but that was on the felony, and this is a misdemeanor. So now that he's pled to a misdemeanor, so I'm going to reset bond. I'm going to modify bond. Because of the failed to appear, I will set a bond, but it'll be a low 10%. It'll be 1,010%. All right, so it's 1,010% for the modification of bond. If you're out, seek the 5th floor for probation, and we'll see you here on June 27th at 9 o'clock. If not, probation will be to see you, depending on the other file and where you're incarcerated. But if you are out, you have 48 hours to go in with probation. All right, sir?
Yes, sir.
All right, and then the bond violation on that contempt, which was due to the assault, is that dismissed at this time, or that's a request by the prosecutor's office on that contempt hearing? That
would be our request, Your Honor.
And I'm assuming you have no objection to that.
No objection, Judge. Thank you.
So bond. Dismissed. And then we're on the record in docket 25-01005. We've already had appearances for the record. Mrs. L, how are we proceeding on that case?
Your Honor, at this time, the necessary witnesses have failed to appear and the people are unable to proceed today. I do expect a motion from the defense on that too.
All right, Mr. Palmer.
Thank you, Your Honor. At this time, the defense moves to dismiss for lack of probable cause by the prosecution.
And the complaining victim was subpoenaed and you haven't heard from her, Mrs. L.
I have not heard from her and we have attempted to contact her multiple times to no success.
Right, I will be in possession of a nollie pros at the request of defense counsel on docket 25-01005 concerning the 2-count assaultive crime, felony crime. This case will be dismissed without prejudice, which means that the people could reissue if they choose to, but realistically today, Mr. Shabazz, the case is dismissed. All right, sir?
Thank you.
All right. All right, I've signed at the request of the council, the motion dismissed without prejudice. Anything else for the record in docket 25-01005, Mrs. L?
Not for the people.
Mr. Palmer?
No, Your Honor. Thank you.
All right, Mr. Shabazz, you're all set. Thank you for your appearance today.
Yeah. Do we need anyone else? Do you want any option about it? What are we?
You have one left, Mr. Palmer?
I do. I don't, he's here. He's president of the quorum. I just need
You just want to talk to him?
Yeah, I just don't know what she wants to do.
Okay.
Yeah.
Are you here being brought up now?
I mean, I know what I want to do with it. I'm ready to do that, but I don't know whether it's.
How about we do one at Strauss instead?
Is perfect.
Yeah, she's ready.
Yeah.
Yeah, she's ready. I talked to her. I think I probably should have
All
town.
right, so Aaron, you're here on on Strauss.
I am, Your Honor, as well as Mr. Tony Austin, but I'm going to need to go talk to him if we can
All right.
negotiate it. And I'm Zachary Kelly's also. Yeah.
Great, so you're ready on.
I'm ready, yeah, we're ready on all. Caleb, you said we're gonna try
We're asking
for
the
transfer.
attorney.
Do you have people living on him? There's some in the hallway who said they would do that.
I did leave all my witnesses on just in case.
Some
our
didn't work.
adjournment was-
Okay.
Yeah, it was a just in case type thing.
Okay. Who did you do that?
I think I don't know. Because I haven't checked on that one.
Okay.